So good afternoon. We say good morning, but it's 12 o'clock, isn't it? So good afternoon. Thank you for joining this webinar. We're going to cover the GDPR implications of COVID-19 or coronavirus tests, so that what the implications are if people are employers are testing their employees and recording information around coronavirus status, taking health temperature checks, that kind of thing. This is obviously in light of people being allowed to go out and about doing their business a bit more as the lockdown eases, but specifically for employers who are looking to bring their employees back to work and maybe doing some form of recording. So first of all, for anyone who doesn't know me, my name is Mark Gracey. My business is called Mark Gracey GDPR. I support businesses with their GDPR compliance through a range of helpline related services where I can provide access to online resources and step-by-step guides, right through to actually doing the work and acting as a data protection officer on your behalf if required. My background is very much a regulatory one. I have a 15+ year career working in the internet industry from a regulatory point of view, of which data protection was a key point of that, having become a data protection manager back in 1998 when the original Data Protection Act came into play. So a lot of what I do with GDPR and working with businesses is based on that experience, and I've been running the GDPR element of my business for the last 4 years. So, as I said, we're going to be talking about the coronavirus testing that you might be doing as an employer, or you might be thinking of doing for your employees coming back to work. My intention is to do a very quick recap of GDPR. We don't have enough time to go through GDPR in too much detail. Look at what the problems are that you're likely to have to think about, and then look about where GDPR fits into the kind of recording and testing that you might be doing, if indeed you are doing it. So let's start with a quick GDPR recap, and I have summarized GDPR in one slide using this diagram. As I said, we don't really have time to go through it in much detail, but just to clarify a few things. GDPR is all about the protection of personal data. So that's data that enables you to either directly or indirectly identify an individual. So obviously, if you're dealing with employees' data, those employees will be your data subjects, and you will be the data controller, and you'll be processing your employees' personal data, and that includes things like their employment records, their name, address, that kind of thing. And there's an element of personal data called special category of data, which is specially protected and includes things like health data, which is why the testing element of the coronavirus checks that you might be doing is covered by data protection, and specifically special category, but we'll come on to that in a bit later on. The rules about what you can and can't do from a data protection compliance point of view are called principles. They're listed there on that second circle on the right hand side. All processing has to be fair, and you have to have a lawful basis, which we'll talk about in a second. You have to be open and transparent about how you're processing data. You must only process data for the specific purpose that you've collected it, unless another lawful basis allows you to process it in a different way. What you collect has to be relevant. You have to keep it accurate and up to date. You can only keep it for a set period of time, where whilst you need it and whilst it's lawful for you to keep it. If you no longer need it and there is no other lawful reason for you keeping it, then you must delete it. All processing has to be done secure, and the GDPR introduced the accountability principle, which is a principle of basically demonstrating your compliance, and accountability is the circle on the left-hand side of that, and that includes things about whether you need to appoint a data protection officer, providing documentary evidence of your processing and that you've considered what's the most appropriate lawful basis for processing. There's tools like legitimate interest assessments if you're relying on legitimate interest as being your lawful basis, data protection impact assessments for risk assessing your compliance, processor due diligence, and so forth. So there's quite a lot of things that you have at your disposal and you're expected to look at from an accountability point of view. And accountability was one of the new principles that was introduced with the GDPR. In terms of lawfulness, this comes down to one of the 6 lawful bases. You have to choose which lawful basis is most appropriate, and we'll talk about that in a second, about where that sits with regards to any recording of health information. But most people will know of consent being the probably the most popular or well-known one. GDPR introduced some changes with consent. We were all inundated with consent renewal emails in the lead up to the GDPR deadline in 2018. But just because everybody knows about consent, consent might not be the most appropriate, and it will depend on the situation, the circumstances, and the legality of that. And there are other ones, contract, so you're obliged to process the data by delivering a service or entering into a service. Legal obligation, the law tells you you've got to process the data in a particular way. If it's in the vital interests of a data subject, then you can process data for those purposes. If you're a public body, then that public task might be the reason you're processing the data. And then there's another quite well-known one, which is the legitimate interest, which is that it's in your interest to process the data, but you have to do a legitimate interest assessment, as I mentioned in the bit about accountability just a second ago. And that covers you in determining that it's absolutely necessary for you to do the processing, that you couldn't do it any other way, and that it's not harmful to the rights and freedoms of the data subject. But we'll talk about lawful basis and where that fits in the topic that we're going to be discussing today in a moment. And then finally, individuals' rights. These are the rights of the data subjects. So this is everything from the right to be informed, which is the reason we have privacy policies, to the subject access right, which is the right for somebody to ask you if you've got their data, and if so, what data, and can you provide a copy of it, to some of the new features like erasure and portability, the right to object, the right to rectify your data, and so forth. So that's GDPR in a very small nutshell, because as I said, we haven't got enough time to go through all this in a lot of detail. But certainly if you need any help in a general compliance point of view, I can obviously help you with that. And I run courses and training sessions that go into these in a bit more detail. So I've kind of set the scene at this point. The next thing to consider is the topic at hand, which is recording of employee data relating to their coronavirus status, which might be you're doing temperature checks as they're coming into work, or it might be that they're telling you that they're not feeling very well and they've decided to self-isolate and request a test. It could be that you're being asked for information about your employees and who they've been interacting with through the NHS test and trace system. And then obviously you need to think about your general GDPR compliance. So the challenge really is that you're going to be collecting data that you probably haven't collected before. You need to think about what you can do with that data, if indeed you're going to do anything. What can you record, why are you recording it, and so forth. What to do if the NHS test and trace system gets in touch with you and wants you to tell them about other employees that have been engaging with the employee who's tested positive, as well as the general GDPR compliance angles around accountability and the legality of the processing. So I've sort of broken this down into a number of areas and look at this from a GDPR perspective. Now, from a COVID-19 guidance and what's expected by the government and the legalities and lawfulness of it, there is obviously some questions about whether you do need to do some of these tests or not, and whether you're required. And you might need to sort of speak to a health and safety or a HR or legal expert to get some specific guidance from that angle. I'm just going to simply, when I say simply, there's quite a lot to cover. I'm going to cover the GDPR angle on relation to the data that you may be collecting. So I've summarized this in 7 particular key areas in terms of where GDPR comes into this. So your processing has to be lawful. So you have to have a very clear understanding of what your lawful basis for processing any particular COVID-19 information, be that temperature checks or somebody telling you that they're they've tested positive and are self-isolating, and what you tell to your other employees and so forth. Because it's health related, it's special category data, which means that it has special protection. So as well as a lawful basis, you have to find a special category condition that applies as well. You have to be very clear as to why you're doing this in the first place. You will need to be clear on what you tell your employees about the fact that you're doing the processing and the use of the data that you might be collecting when you're doing the tests or being told certain information. You need to, because of accountability, demonstrate your practices are compliant. You need to bear in mind some of the restraints around the use of technology and what monitoring you might be doing, and certainly there are limits on what's allowed from a monitoring of employees perspective, and you need to consider the implications of being asked for information, be that test and trace or having to tell other colleagues that they might have to go home and self-isolate and get tests on the basis that one of their colleagues has fallen ill. So let's look at those in a bit more detail. So which lawful basis is going to be the most appropriate one? So when we talk about collecting this information, we're going to be talking about employees. Now, rarely, and I've kind of I've sort of given the answer away, I guess, because I've highlighted the ones that aren't appropriate in red and the ones that are in green. But just to work around this diagram, rarely in employment data sense is consent relevant. There's a big issue around the fact that employees may feel compelled to consent when they wouldn't necessarily want to, for the sake of saving their job or not missing out on a promotion and stuff like that. So very often it's very rare that you can rely on consent when you're dealing with the processing of employee data, because of that imbalance, and the GDPR consent rules require it to be a freely given consent, rather than somebody thinking, well, actually I better give consent because it might have implications further down the line or in some other area. So consent is very rarely an appropriate lawful basis, so you definitely can't be relying on that in this particular scenario. Contract, well, testing people for the COVID-19 infections or likelihood of infections like temperature tests, those kind of things are unlikely to form part of an employment contract, so contracts not likely to be appropriate. I'll skip legal obligation and come back to that in a second. Vital interests, again, not applicable, because vital interests can only be used as a lawful basis when you can't interact with the individual and perhaps get their consent or talk to them about what it is that you're planning on doing. Public task is not going to apply unless you're involved in a public body related processing activity. So that's not relevant, which really leaves legitimate interest or legal obligation. Now, the legal obligation one is slightly less likely. The ICO favour legitimate interest and suggest in their guidance legitimate interest is probably the most appropriate lawful basis. Legal obligation, the guidance, as I understand it, is purely that. It is guidance. It is not a legal obligation for you to well, in fact, I don't think even the guidance sets out that you have to take temperature checks or manage data relating to somebody's conditions of health. It's very different than the pubs and restaurants and bars, which are hoping to open on Saturday, where they have been told they've got to record customer details, and that's from a health and safety perspective rather than a legal obligation. But health and safety is more of a legal obligation in that scenario than it would be from an employer-employee relationship perspective. So is legal obligation the right lawful basis? Well, if employment law requires it, or from the circumstances within which you're operating, health and safety law may require it, then you may be able to rely on legal obligation. But as I said, the Information Commissioner's Office, the regulator in the UK, feels that legitimate interest is probably the most likely, because the guidance doesn't mention about the fact that you should be testing employees when they come into work or monitoring their health while they're in work. And therefore, you are doing this as something that you believe is in the interests of yourself and your employees, to make sure that you mitigate any risks of an infection spreading. So all things considered, legitimate interest is probably the best way to go forward. And that means you really ought to document that decision based on carrying out a legitimate interest assessment. So that's the lawful bases. Whatever you do, don't use consent, because that's not going to be appropriate when dealing with employees. And the ICO suggests, and again, I always say this, the suggestion bit is quite key when it comes to the ICO, because they'll very rarely give you a very clear yes or no answer on things. So that's why I think you should rely on legitimate interest, but carry out a legitimate interest to be sure that you've considered all the implications and documented why you believe it's the most appropriate, just in case somebody starts questioning it. Now, when it comes to special category of data, which of course, if you're recording information about somebody's health, be that a temperature because you've done a temperature check, and I've spoken to various organisations who are looking at recording employees coming into work and recording their temperature on that particular day. Even the temperature itself is related to somebody's health, and therefore you are handling what's called special category of data. Now, special category of data covers much more than just health data. It covers trade union membership, religious beliefs, sexual orientation, biometric data used for identification purposes, and so forth. And the key thing with special category data is not only do you need to determine the lawful basis for the processing, but you need to determine a special condition. And these are set out in Article 9 of the GDPR. And essentially you determine that legitimate interest is your lawful basis, but what's the special condition that applies for the fact that you're processing special category data? Well, actually Article 9(2)(b), which is the employment, for the purposes of employment, social security and social protection, is likely to be your most appropriate special condition to rely on. And in fact, again, the Information Commissioner has highlighted that they believe that's probably the most appropriate. The downside is when you're processing special category data, or certain special categories of data, is you may also need an appropriate policy document. There's a template on the Information Commissioner's website if you go to the special category section. This is essentially a part of the accountability principle, but it's a requirement of the Data Protection Act 2018 rather than something that the ICO have introduced. But this document is a way of you documenting your special category processing activities, considering the lawful basis, considering the special condition, considering how long you're going to keep the data, what you're going to do with it, and so forth. So if you're going to be doing this checking of somebody's health and recording the information, then you need a lawful basis, and because it's health related, you need a special condition, and you'll also need an appropriate policy document as required in the Data Protection Act 2018. Now, the baseline starting point though is, why are you doing this? Do you need to record this data? Do you need to do anything more than just test an employee when they walk into the office? Do you need to record any particular information? If you don't, then you're going to struggle to find that there's a clear purpose. And as I mentioned very quickly when I was talking about GDPR, one of the key things is, one of the principles is that you only process data for a specific purpose. So is your processing absolutely necessary? Do you need to write down the temperatures as people come in, or do you just need to observe that this person you don't need to record anything because nothing has occurred, or this person has failed a temperature check and you're going to send them home, and you just need to document that, although you need to be careful that would still be personal data depending on how you're documenting it, and could be considered special category data on the fact that it relates to their health. You need to understand what you're going to be doing with that data, because you need to be very clear about the genuine reason why you are doing this. Do you need to keep the data? Will it be part of an employment record? What else might you be doing with it? What do you do if you end up with a positive result, be that somebody who fails a temperature check, or calls in sick because of the fact that they believe they might be positive and therefore need to send off for a test and are self-isolating, obviously that's probably a slightly easier way of looking at it on the basis that they're calling in sick, and you will already have protocols in place for dealing with sickness and recording that against employee records. You need to be clear about how long you're going to be keeping the data. You know, if somebody is tested today, do you need, so I'm talking about temperature checks here, do you need to keep that for what, 7 days, 14 days, 21 days? The pubs, bars and restaurants have been told they should keep it for 21 days. So should you be keeping your records for 21 days? Well, you need to determine that, and you need to have a clear retention policy around what your decision is with regards to that. If you're literally only doing it for, we checked this employee and they didn't test high on a temperature check, and you are keeping it for 2 weeks as as sort of the self-isolation period dictates, then that would be your justification for retaining it for, say, 14 days. But you need to determine that, and that's going to be tied into why you're actually doing this, and is there a necessity in you recording it. Everything you do has to be done securely, so all processing data, data processing even, has to be done with security in mind. The GDPR talks about making sure that you have appropriate technical and organizational security in place. Now, if this is tied in with your your HR records, then hopefully you've already got protocols in place to secure your HR data, so that the HR team are the only ones who have access to it, that other people, you know, no matter where it's stored, can't get access, so it's securely locked away, or it's on a file sharing server where the directory or folder is being locked to only certain people. Whatever that process might be, the same security principles need to apply here, not least of all because it's health related, and that special category of data has that special protection element of it. So whatever you're doing with your HR records in general, you probably ought to apply to your COVID test data information as well. So and so think about who's going to have access to this data. You know, if you're having a sign-in sheet where somebody is self-testing as they arrive on the premises and recording the temperature and writing that on a log sheet, they'll be recording their special category of data on the log sheet for everyone to see. Now, is that a most appropriate security? Probably not, on the basis that people who don't need to see that Fred Bloggs came into the office and tested low on a temperature, or whatever that temperature might be, is giving away personal data, and I would say that that's not secure. So you need to have a proper, appropriate process for dealing with that security of that data. Obviously, if you're doing it on a digital device, then again, you've got to think about the device security. What happens if the device goes missing? Where's the data being stored from the device? Are you storing it on a third-party server, in which case that becomes a data processor? Have you carried out due diligence, etc., etc.? And that all falls in with the accountability principle and how that applies. So you have to be able to demonstrate that your purpose is valid. So, you know, you're collecting data for a specific purpose. What is that purpose? And that purpose was necessary. You need to get that into some kind of policy or documentary evidence or even update your data inventory to indicate that you've considered that this is new data that you're collecting. You need to also consider individuals' rights. So whether you've decided to, you know, whether you've come up with the idea of that this is what you're going to do, and you're clear that it's appropriate for you to do it and it's lawful for you to do it, but you can't ignore that the data subject, which in this case will be your employees, they have individuals' rights, and those rights will apply to this data as much as it does any other data that they're entitled to. So the most obvious one is they've got a right to understand what you're going to be doing with this data. So that means you need to have some form of privacy statement, whether that's updating your employee privacy policy, if you've got a separate employee privacy policy, or your general privacy policy, or a separate statement at the point at which you're communicating that this is what you're going to be doing, or actually doing the tests at the time. You need to communicate to them everything that Article 13 of GDPR requires, which is about we collect this data, this is what we do with it, this is how long we will keep it, these are your rights, this is how you can complain, this is who you need to speak to if you've got any concerns, and so forth, and also why you believe it to be lawful. So considering all of the things that we've discussed, the lawful basis, the special condition, the necessity in you doing the recording in the first place, all needs to be communicated, and that's the right to be informed, which typically leads to somebody having a privacy policy or some form of statement at the point that the data is collected, or signposted at the point that the data is collected. Either way, you need to make sure that you get that message across to the employees. They will have the right of access, so that's a subject access request, and the ability to ask you for copies of the data and what you're doing with it, and you have no choice but to comply with that. You get a month to deal with it. You can't charge generally. There are a few exemptions, but generally speaking, you can't charge for it, so you have to provide that information for free. If they have the right to rectification, which is about keeping data accurate, so which is one of the principles. So they could ask you to correct some data if they felt it was incorrect. They could ask you to erase it. Now, this is going to be a tricky one to decide on whether it's appropriate or not, because the right to erasure is not an absolute right. So that means that if it is lawful for you to continue to process that data, then you have to be able to demonstrate that and say that you're not going to erase it. But potentially an employee could say that they don't want you to keep that data on them anymore, and unless you can demonstrate that it is appropriate for you to keep it, then you're going to have to delete it. And then there's a whole host of other restrictions around what data subjects or the employees have a right to exercise. So they could ask you to restrict the processing, they could object to the processing. So as well as thinking about whether you want to be doing the recording and whether it's appropriate for you to do the recording of say temperatures, then you need to consider the fact what happens if a data subject or an employee turns around and says that they don't want you to be doing this for them anymore. What if they object? You will be hard pressed to argue against them saying no if you're relying on legitimate interest as your lawful basis for processing. So the message here is, don't forget your employees have data rights, and the most likely one that you'll probably come up against is the fact that you need to meet this right to be informed. So that means get a privacy statement ready and provide it to your employees so that they know what you're going to be doing with that data. Now, when it comes to being compliant, the accountability principle basically says it doesn't matter if you think you're compliant, you've got to be able to prove it. And fitting within that accountability principle, we've covered a few of these things already. I'll come back to data protection impact assessments in a second, because this is quite a pivotal thing for you to consider. But just to highlight some of the other areas, I've talked about legitimate interest assessments already. If you're going to be relying, which you most likely are, on legitimate interest as your lawful basis, you really ought to carry out the 3-point test, which is called a legitimate interest assessment, or LIA. There's a template on the ICO's website you can use to do that. You will want to make sure that you're recording your data processing activity, as I mentioned before, and that might be you've got a data inventory that's you need to update. And certainly if you haven't got a data inventory or some way of having documentary evidence of your processing activities, then you're in breach already of the accountability principle. Arguably, if you're not doing these checks very often, then you might not need to document it, because if you're under 250 employee organization, because under 250 employee organizations only need to document regular processing activity. If you're over 250 employees, then you have to document every single different type of processing activity, regardless of how regularly you do the processing. You should have internal policies. I've mentioned policies and procedures already, but you should have a clear policy approach to what you're doing and why you're doing it, how you're going to keep the data, what you're going to do with your retention policy, and so forth. So I would strongly suggest that you have a policy that covers this activity and sets out, if necessary, a protocol for those who are involved in doing the testing or doing the recording, depending on how you're doing it. The concept is, how can you prove that you are GDPR compliant if you don't know what data you're processing, which is why you need a data inventory or some kind of documentary evidence. And if your staff don't understand what they can and can't do from a data protection point of view, which is where a policy comes in, and also usually associated with policies is training. So making sure that if you need to, that you train the employees that might be involved in the processing activity. Obviously, if you're using your HR team, then they probably already have the appropriate understanding of what they can and can't do from a data protection point of view. If you suffer a breach, so somebody accesses the health-related data, then there's a good chance you will break the threshold for reporting a breach. So there's 2 thresholds. Within 72 hours of becoming aware of a data breach, you have to report it to the Information Commissioner if there's a risk to the individual. So you have to balance up the circumstances of the breach and what that means in terms of potential harm to the individual. And if there's a high risk to the individual, you've got to tell the individuals as well. So make sure you're clear on your breach processes and procedures internally, and also that your staff understand what a breach looks like, and realise that it's more than just a cybersecurity hacking incident. It's the accidental deletion, manipulation, or changing of data, as well, loss on a device or whatever. So there's a number of different things that need to be considered from a breach perspective. And you would have to think very carefully, and that this is the problem with dealing with breaches, is you have to think them on a case-by-case basis, but you'll need to think carefully about whether you make these thresholds for harm to the individual, which requires you to report it to the ICO, or high risk to the individual, in which case you have to report it to this individual as well, where the risk-based test is around not just whether it's financially going to lead to identity theft or financial loss. It's also mental and physical health as well, and how that might be interacting in the circumstances of where you're operating. So, and then bring it back round to data protection impact assessments, or DPIA. These are risk assessments where you're basically looking at your processing activity and determining what the risks are, and working out how you're going to mitigate those risks. And in very extreme circumstances, if you can't mitigate a risk, you also have to engage with the Information Commissioner. Now, in the GDPR environment, GDPR says you have to carry out data protection impact assessments if you're processing high risk data, of which special category of data is typically referred to as high risk data. So GDPR pretty much tells you need to carry out a data protection impact assessment. But regardless of that, the Information Commissioner's view is that they've had privacy impact assessments, which are the same thing as best practice for some time, and therefore you should carry out a data protection impact assessment whenever you do something new with some data. So you're now thinking or doing some processing of a different set of data relating to your employees. You really ought to document your risk-based approach to that in a data protection impact assessment. And that, at a very simple level, can just be a document that lists what you see to be the risks and how you're going to mitigate those risks. Or you can use the ICO's template, which is available on the website, and I think they've got some. I think they still use them. Some initial questions to determine whether you need to actually carry out the full impact assessment. But I would suggest, regardless of the initial questions, you really ought to have some documentary evidence to consider how you're doing it. Whether this ties in with your policy or not is up to you, but how you're doing it, what you're doing, what the risks are, the way you're implementing it. Are there risks to the security of the data? How do you mitigate those risks? That's the kind of approach. So really, I should have probably talked about data protection impact assessments at the beginning, but I wanted to sort of fit it into some kind of flow, and it fits much better within the accountability principle, which is why it's here. But ultimately, before you do it, you should carry out a data protection impact assessment, because that fits within the GDPR's requirement of considering data protection by design and default. So you're doing something new. How do you make sure that it's data protection compliant? Carry out a data protection impact assessment to consider the risks and how you're going to mitigate those risks. So if you haven't done one, I suggest you do one, even though it might be retrospective, just so that you make sure that you can demonstrate that you've thought it all through and you've done something about anything that you've highlighted as a particular risk, specific, especially because you're going to be processing health-related data, and that special category which has these special protections and is considered to be particularly sensitive from other elements of things like breaches and people seeing it when they shouldn't do, for example. So if you take anything away from this slide, it's do a data protection impact assessment. And then just something that the ICO touch on a little bit, although they're a little vague, as is often the case with these things, is about just bear in mind some of the constraints around what you might be doing from a technology point of view. So if you're using heat analysis cameras, CCTV that's able to do monitoring and show you where if somebody's got a particular temperature and that kind of thing, and you're doing this in an automated way, there are lots of different things you need to consider. Particularly, is there a less privacy intrusive way of doing it, which is maybe setting out an alternative approach to using monitoring technology to monitor your employees. As I said on the left-hand side of that slide, if there's an easier way, then use that rather than rely on technology automation to help you. And again, data protection impact assessment is a must in that scenario. Don't even start thinking about technology that might be able to help you track infections and or even monitor employees, which may be also construed as monitoring their behaviours if you're constantly recording their whereabouts in an office or whatever. You must carry out a data protection impact assessment. So really, that's a sort of a heads up, which I guess is really the point of what the ICO have said in their guidance, is that be very careful and be mindful that if you're using camera technology or some other way of testing for health, which is automated and can be construed as monitoring of employees, there are strict regulations from a HR point of view as much as a GDPR point of view. You'll need to be very clear to your employees that that's what you're doing, and they have a right to at least have a discussion and an objection, particularly if there are any kind of automated decision-making processes taking place as well. And then finally, I just wanted to touch on some of the scenarios where you've got this data and you've gone through all these checks and balances, you've carried out your data protection impact assessment and determined that this is the right way to go forward. You're doing the recording, you're clear on your necessity and your purpose. What happens with the fact that somebody might want to get access to that data, or you may need to communicate something as a result of the data that you've found out? And probably the two key areas to consider are other employees and the NHS test and trace system. So if your employees are working in a confined space, then the guidance from a COVID point of view is about potentially if you've come into contact with other people, you need to tell them so that they can go and self-isolate. So you have to be careful how you manage that in an employer situation, but you can tell other employees because it's in their interest to protect themselves that they might need to they will need to go and self-isolate, but you should try and avoid giving away too much information or giving away even the name if that's possible. So if there's multiple employees, that's much easier to say, actually, a number of employees have gone off sick and they're being tested for COVID-19. We need you to go home and self-isolate. And if you get symptoms, go and test and follow the test and trace process and so forth. If it's a team where only one person has rang in to say they've tested positive, or you sent them home because their temperature seemed to be high, then it may be less easy to not give away who that individual was, but you should minimize the amount of information you give out, and if possible, avoid indicating who the individual might be that's been affected. Now, there is a potential, I don't know from an employer's perspective whether this is likely. As I say, that there's no obligation in the guidance from the government to record the data of your employees for the purposes of helping test and trace, which isn't the case for the hospitality industry, who have been told they've got to keep data for 21 days for customers and visitors to their venues because of the test and trace system. But you know, potentially somebody could test positive, get into the test and trace process and say, hey, I worked in an office or a factory with a number of my colleagues, but I couldn't tell you which ones were in, and you could be therefore contacted by test and trace to see if you've got any records of people who have been ill. So you should have a protocol around that potential contact from the NHS test and trace service, to how you deal with it. How do you make sure it really is them, and that they're entitled to that data, and you're very clear on that process. Yeah, you need to have an internal policy and an approach to dealing with external parties like the test and trace who might want to get access to the data for legitimate reasons, but you need to be clear that those legitimate reasons are balanced against the rights and freedoms of the employees, and also that you really are dealing with test and trace and it's not somebody trying to get access to data. So have a clear process in place for dealing with that. And you also need to be careful if you get, you know, media contact or PR contact, not to give too much away about, well, not to give any information away about specific individuals, and being very careful what you say to any other third party, because you are dealing with employee data, which is covered by GDPR, and therefore you can't give that out without the employee's permission. But I think, to be honest, the most likely chances are you will have to consider the scenario of what you say to other employees that may be needing to take some further action themselves because of an employee testing positive. So I'm mindful of the time. I've obviously rushed through that quite a lot and covered quite a lot of different areas. I've not gone into a lot of the GDPR detail, but I did want to highlight the main areas of GDPR that apply if you are recording the temperatures or some kind of health related information to do with coronavirus as you get employees coming back to work, or if you're already doing it, or whether you're thinking about it, doesn't really matter, but you need to think about these GDPR implications. And I can't stress enough, the best starting point is, do you really need to do this? If you do, carry out a data protection impact assessment and weigh up the ways you're going to be doing it, what the risks are from a data protection point of view, and how you're going to mitigate those risks. If you need to help, just very quickly, I provide a range of different services. They're all support based, although I can do ad hoc pay as you go help. But if you want to have some assistance in determining what you should and shouldn't be doing from a GDPR point of view, if you need input on a data protection impact assessment, for example, then I have some services that can help you with that. And the GDPR Unlimited product is unlimited email and phone support, on access to our online resources, plus you get hands-on help as well, up to 4 hours a month. So I can actually take away some of the complexity and the pain of having to deal with these things for yourself, and you can be a data protection officer. I can be a data protection officer for you with that package as well. But do get in touch or have a look on my website if you want to know more about how I can help you with any GDPR related thing, not just what we've discussed. If you want to get involved in a discussion further about this, I have what I call the Article 13 Club. It meets online on the first Tuesday of each month. So the next one's on July the 7th, next week, next Tuesday. And the topic will be very similar. We'll be talking about the employee data and recording information relating to employee records. So it's not a presentation, it's very much a chat discussion of data protection practitioners and various angles from a HR and a health and safety point of view as well. But it's very much a discussion group attended by a mixture of people from data protection officers to people who have either feel they've been lumbered with data protection and just want to have a support group, or people who, you know, a one man, one woman business that just needs that input. It's free to attend. Have a look at my website, follow the link to the Article 13 Club, and you can sign up there. And if you're really interested in getting to the bottom of the detail of GDPR, then I have a 10-week weekly workout looking at various details of GDPR in a lot of detail. So I'm just coming to the end of the first 10 weeks, where you're more than welcome to jump on the last couple, or or start the next batch, which start in August, I think it is. But again, have a look at the website, look at the training session, and have a look at what that's involved if you're interested. So I've got a bit of time for questions, and in fact, I've had a few comments come through the chat. Okay, thank you for the good feedback. Okay, hang on, let me just have a look at some of these questions and see if I can provide the answers. Would I be able to check the temperature of learners for training sessions? Dealing with care professionals, you know, there's potential that it could, well, it's a serious implication. So I think that the question there is, you know, should you be doing checks, and is it relevant, reasonable for you to do it? I think the answer to that question is, because you're dealing with care professionals and you've highlighted the risks that are probably going to be for potential care professionals spreading it amongst other care professionals, which they could then take back to their care homes or wherever it is that they're working. That seems like a reasonable way of doing it. And it's not that the law stops you from doing it. The guidance doesn't require you to do it. And the guidance kind of, I suppose, if you're, depending on how you're delivering your training, I'm not quite sure where the government sits on those kind of things. We're supposed to be avoiding contact if we can. But I think that it would be reasonable for you to carry out those temperature checks for the reasons that you set out. You just need to make sure you put in place all these checks and balances that I set out. So yeah, I hope that answers the question, but feel free to follow up if not. Okay, and thank you. A few comments saying thanks for the presentation. So I think that was actually the only question. So yeah, I hope that was a helpful answer. I can hear people dropping off, so I guess that